Hello everybody, it's Bronwyn Barter here from GP Connections. So thank you, Matt, for doing this webinar today on privacy changes that took effect on the 12th of March. Please remember, everybody, if you'd like to ask Matt a question, to type it in the chat box on the lower left hand of your screen. So with that, thanks very much, Matt, and I'll turn it over to you.
Thanks, Bronwyn. As Bronwyn's mentioned, today I'm talking about Australian privacy changes. The law changed on the 12th of March 2014, and so we're talking about changes to the Privacy Act, which is a Commonwealth piece of legislation. The way we've structured the webinar today is, firstly, we'll just have a very brief overview of what's happened. We'll look at some of the key terms. We're going to spend most of the session on having a look at the Australian Privacy Principles, which are a new set of principles. We'll look at some general exclusions and some health exclusions. Okay, so privacy in Australia concerns personal information. So we're looking at information that relates to individuals. So we're not looking at information relating to corporate entities. As I said, the changes have taken effect from the 12th of March of this year. Now, the drivers for the change, the Privacy Act is a reasonably dated piece of legislation. I think it's 1988. So it hasn't been updated for some time. Now, the drivers have been technology, the increased use of cloud computing and online forums to collect, use and disclose personal information, and also based upon emerging privacy issues in Australia and around the world. So there's 13 Australian privacy principles, and for organisations they replace the national privacy principles. The idea behind the Australian privacy principles was to harmonise information privacy principles and national privacy principles. So the NPPs related to private sector organisations in all states, and the IPPs related to the Commonwealth agencies and some public sector agencies in Queensland. The APPs are structured on the information life cycle, so it's got everything to do with how personal information is handled, starting with the collection, use and disclosure, ensuring the quality and security of that information, and that individuals have access to the information and can seek its correction. The amendments to the Privacy Act also included new provisions related to credit reporting. I've just identified that. This session we won't investigate that at all, but it's just worth noting if you're involved in in businesses which provide credit of at least 7 days credit terms, then the credit reporting provisions may apply to them, and that's a whole new regime. There's a code of practice which relates to that, but that's the subject of a subsequent presentation. One of the most important changes were the enhanced powers given to the Privacy Commissioner, and there's been a lot of press about the increase in the fines faced for serious or repeated contraventions. So the maximum for an organisation is now $1.7 million, and for an individual it's $340,000. Now, if a fine is handed down, an individual affected by the breach can apply for compensation, including if their feelings are hurt. The Commissioner's powers also give more far-reaching investigative powers. The Commissioner can come in and assess documents and assess your process and your procedures. There's code-making powers, and the Commissioner can also hand down enforceable undertakings. So for the purpose of the Privacy Act, we're dealing with two types of entities. So it's an APP entity. You're either an agency, and that's the government side of things, so a minister or department. The purpose of the presentation today is really to focus on the APP entity being an organisation. So that's an individual, a body corporate, a partnership, an unincorporated association, a trust. That's not a small business operator or any of those other prescribed things there. There is an exception, and the way the Privacy Act is drafted, it'll provide general provisions, and there'll be a number of exceptions throughout, and you'll see that when you go through the Australian privacy principles. So some small businesses must still comply, and most relevant there is a small business which provides a health service. Other small businesses which have to comply are those that disclose or receive personal information for a financial benefit, or where the small business is a contract service provider to the Commonwealth Government. There's still the same threshold for a small business, so you're looking at turnover of less than $3 million per annum. And the definition of personal information is up on the screen now. So you're looking for any information or an opinion about an individual. It's got to be reasonably identifiable, and it doesn't matter whether it's true or not, or whether it's recorded in a material form or not. So with personal information, the key things to look out for are, does it relate to an individual? Is it reasonably identifiable? Another form of personal information is sensitive information. That includes health information about an individual, genetic information about an individual, and biometric information. It also includes things like race, sexual preference. So the heads of discrimination, or the heads that anti-discrimination legislation was set up to protect. So health information has a detailed definition. So you're looking for information or opinion about the health or disability of an individual. An individual's expressed wishes about the future provision of health services to them. A health service provided or to be provided to an individual. That's also personal information, so it's reasonably identifiable. It's other personal information collected to provide or in providing a health service. Other personal information about an individual collected in connection with the donation of body parts, organs or body substances, and genetic information about an individual. So an APP entity has the primary obligation to comply with the Australian privacy principles, and also to any code of practice that may apply to the entity. So jumping into the Australian privacy principles, APP 1 deals with open and transparent management of personal information. The most important thing here is the content of an APP policy. It must include the information which is prescribed in APP 1. The APP policy must be freely available. Most commonly that's going to be located on websites. And the APP entity or the organisation must take reasonable steps to implement processes that will ensure compliance with the APPs and any registered APP code. So it's this implementation of processes which is going to be the most work for organisations out there. The policies are more prescriptive, but they generally include the information that they used to. It's the processes that need to be put in place to ensure compliance that is going to be more work. APP 2 gives an individual the ability to interact with an organisation by either not identifying themselves or using a pseudonym. Now that's permitted unless the organisation is required or authorised at law to deal with individuals who have identified themselves, or it's impractical for the organisation to deal with individuals who have not identified themselves or have used a pseudonym. APP 3 deals with the collection of personal information and also sensitive information. So personal information must not be collected unless it's reasonably necessary for one or more of the entity's functions or activities. And in your APP policy, you'll need to set out what those functions or activities are. The personal information must also be collected from the individual unless, there are a couple of exceptions, unless that's not possible or it's not reasonably practicable. Now, There's a higher threshold for sensitive information. Sensitive information must not be collected unless the individual consents and the information is reasonably necessary for one or more of the entity's functions or activities, or the collection is required or authorised at law. APP4 sets out the rules for dealing with unsolicited personal information. These are new provisions for how you need to handle information which you have not solicited or sought. And the first test there is you need to assess whether that information could have been collected under APP3. And remember, APP3 is where you are required generally to collect that information from the person themselves. If the answer is no to that, then you need to either destroy the information or de-identify the information as soon as possible, if it's lawful to do so. APP5 deals with the notification of collection. So where organisations collect personal information, there's a requirement to inform the individual that their personal information is being collected, and that's commonly referred to as the collection statement. The collection statement will also need to have details about how that individual can access, correct, and complain. That information is in the APP privacy policy. But the collection statement deals with who you are as an organisation, how an individual can contact you, why you're collecting that information, whether you've collected that information from third parties, what happens if you don't collect the information, and the complaint handling process. It also needs to specify whether there's the potential for overseas disclosure. APP6 sets out the rules for use or disclosure. Now, with the rules for use or disclosure, generally there's a requirement that the organisation only uses the personal information for the purpose for which it was obtained. There are some exceptions, and those exceptions relate to use or disclosure for a secondary purpose if that's been consented to by the individual, or to locate missing persons, to establish, exercise or defend a legal claim, or to be used in confidential alternative dispute resolution. APP7 deals with direct marketing. Essentially the rule is that it's prohibited except in limited circumstances. And the limited circumstances are things like the individual has a reasonable expectation that their personal information would be used for that secondary purpose, and there are provisions allowing the individual to opt out if they don't want to continue. Similar opt-out provisions under the Spam Act, except the opt-out provisions also need to relate to hard copy or other forms of direct marketing. APP8 deals with cross-border disclosure. Essentially, an organisation is required to take reasonable steps to ensure the overseas recipient of confidential information does not breach the APPs. And Australian organisations can be liable for a breach by an overseas recipient. There are limited exceptions again, and the exceptions generally relate to where the overseas recipient has a parallel type of privacy regime. APP9 deals with adopting, using or disclosing government-related identifiers. There's a general prohibition which prevents organisations from adopting or using government-related identifiers as their own. There is an exception in the health service area where either it's required or authorised by law, or a health service provider uses an individual's healthcare identifier as their own identifier. APP10 deals with quality. It's just the changes here are to make it far more onerous on ensuring quality. So an organisation must take reasonable steps to ensure personal information collected, used or disclosed is accurate, up to date, complete and relevant for the purpose of the use or the disclosure. APP 11 deals with security. Now it's broader than the National Privacy Principle number 4 because it requires an organisation to take reasonable steps to protect personal information it holds from misuse, interference, loss, unauthorised access, modification or disclosure. So to protect it from interference is a new provision. Now there's also some exceptions there about when you're required to destroy or de-identify personal information. Essentially the test is if it's no longer needed, you need to destroy it or de-identify it where you're permitted law to do so. So from a lawyer's perspective, we must keep certain documents for 7 years. There's similar provisions in other industries. APP 12 deals with access. So there's a requirement to respond within a reasonable time frame for a request from an individual for access to their personal information. Now, the individual must obviously verify their identity, and where reasonable and practical, access should be provided in the manner that the individual requests. Organisations can refuse. There are a list of reasons as to why you can refuse. But if you do refuse a request for access, you've got to provide the reasons for the refusal, and you also need to provide details of the complaint mechanism, so how the individual can take it further if they wish to. It's possible for a charge to be incurred for access, but that charge can't relate to when an individual makes the request, and it can't be excessive. So if you receive a request and to give effect to the request, you need to utilise staff to locate records, potentially copy records, then you can on-charge those costs. It can't be excessive and it can't be unreasonable to impose those costs. So if you're charging more than it actually costs you, you'll fall foul of APP 12. APP 13 deals with correction. So an organisation must take reasonable steps to correct personal information if the organisation is satisfied that it should be corrected, or if an individual requests its correction. Now, if an organisation refuses to correct personal information, it must provide written reasons for why it won't correct the information, set out the details for the complaint mechanism again, and a statement if it's requested by the individual. And that statement needs to be kept with the personal information. Essentially, it says something along the lines of the individual has requested correction of the personal information and that has been refused for whatever reasons. The response time is not specified, it just must be reasonable, and that relates to a request for access and also a request for correction. So with all of those 13 APPs, there are certain exceptions, and they're called either a permitted general situation, where non-compliance with the APP is permitted, or there are permitted health situations where non-compliance is permitted, and they're generally dealt with in each of the APPs. So in relation to the general exclusions, these are situations where APPs can collect, use or disclose personal information or a government-related identifier of an individual. We expect there'll be some more rules made about this, and they'll be published before too long. So the first general exception is so an organisation, in relation to personal information or a government-related identifier, can use that information if it's unreasonable or impractical to obtain consent, and if the entity reasonably believes it's necessary to lessen or prevent a serious threat to the life, health or safety of an individual or to public health or safety. The second general exclusion relates to a suspected unlawful activity. So an organisation in relation to the personal information or the government-related identifier must have reason to suspect unlawful activity or misconduct of a serious nature that relates to the entity's functions or activities that has been, is being or may be engaged in, and the organisation reasonably believes that it's necessary to take appropriate action in relation to the matter. The third exception relates to locating reported missing persons. Organisations can use personal information when it reasonably believes the collection, use or disclosure is reasonably necessary to assist locate a person who has been reported missing, and the collection, use or disclosure complies with the Commissioner's rules. Now the fourth general exception relates to legal claims. An organisation can use personal information where it's reasonably necessary for the establishment, exercise or defence of a legal or equitable claim. The next general exclusion is reasonably similar. It relates to dispute resolution. So it can be used where it's reasonably necessary for the purpose of a confidential alternative dispute resolution process. Now an agency, so we're getting into the government here in relation to personal information, can use personal information where it has a reasonable belief that it's necessary for the entity's diplomatic or consular functions or activities, and the last one relates to the Defence Force. So it can use personal information where it's reasonably necessary for the, certain things to occur, when certain things are occurring outside Australia, and that's related to war, peacekeeping or civil aid or humanitarian activities. So turning now to the specific health exclusions. So the first one relates to the collection of personal information. So if the information is necessary to provide a health service to an individual, and the collection is required or authorised by an Australian law, or the information collected is in accordance with the rules established by a competent health or medical body that deals with obligations of professional confidentiality which bind the organisation. So if you're collecting personal information to provide a health service and you satisfy those criteria, you satisfy the specific health exception. There's an exemption enabling organisations to collect personal information for research, but that collection must be necessary for research relevant to public health or safety, for compiling of statistics relevant to public health or safety, or for the management, funding or monitoring of a health service, and the purpose cannot be served by the collection of information in de-identified form. It's impracticable to obtain consent, and collection is required by an Australian law, or it's in accordance with the established rules or approved guidelines. The third specific health exclusion relates to when personal information can be disclosed for research purposes, and in that, to satisfy that exclusion, the use or disclosure must be necessary for research or compilation of statistics relevant to the public health or safety, and it's impracticable to obtain consent, and the use or disclosure conducted in accordance with the approved guidelines. The fourth specific health exemption relates to when personal information can be used or disclosed, and specifically that's genetic information. So the information must be obtained in the course of providing a health service to an individual. The organisation must reasonably believe that the use or disclosure is necessary to lessen or prevent serious threat to the life, health or safety of a genetic relative, and the use or disclosure conducted in accordance with the approved guidelines. So you're looking at the NHMRC guidelines there. And for the disclosure, the recipient of the information is a genetic relative of the first individual. The final exemption here is disclosure disclosure involving responsible persons for individuals. So if the organisation provides a health service to the individual and the recipient is a responsible person for the individual, and the individual is physically or legally incapable of giving consent, or physically cannot communicate consent to the disclosure, and the carer provides the health service, the carer which provides the health service is satisfied that the disclosure is necessary to provide the appropriate care or treatment, or disclosure is made for a compassionate reason, and the disclosure is not contrary to any wish expressed before becoming unable to give consent, or of which the carer is aware or could reasonably be expected to be aware, and the disclosure is limited to the extent reasonable and necessary to provide care or treatment or compassionate reasons. So the recommendations that we're providing in relation to compliance with the Australian privacy principles are really to audit your current policies and your procedures. So you need to be updating your privacy policies and your privacy collection statements. Your credit policies, but they probably won't relate to this profession. And looking at your opt-out statements for any direct marketing. So you should be familiar with the opt-out provisions if you're doing this online. It's just making sure that you've got similar opt-out abilities in your direct marketing if the direct marketing is paper-based. You'll also want to be spending a bit of time auditing your current procedures and systems to make sure that you're collecting the information according to the APPs, and that's of course subject to the general exceptions and the specific health exceptions, that if you are collecting sensitive information, you're doing that with consent, you're identifying any unsolicited personal information, you're dealing with direct marketing, there are systems in place to ensure the integrity of personal information from a quality and currency perspective, and that you're protecting personal information. You've got procedures for when you need to destroy or de-identify personal information, and access, correction and complaint handling mechanisms are in place. So if you don't have the documents, then you need to develop new ones. You need to ensure that your staff are trained in how to handle this type of information, and you're reviewing contracts just to make sure that you're aware of any potential overseas disclosure, because you can be liable for what is for how that information is handled by the overseas recipient. Now, we've whipped through the slides. I didn't expect that we'd get through the 50-odd slides in only half the amount of time. So, does anyone have any questions? Yeah, potentially there are. So the question that's come in is, are there problems sending out group emails or calendar entries that show all email addresses? If those emails are going outside of the organisation, well, potentially you're identifying personal information. You've also got to look at, well, whether the people involved in the group emails have consented to it. So we'd need a bit more detail just to determine whether there are going to be privacy issues, but essentially if that is personal information that's identifiable, there potentially is an issue, yes. So the question that's come in from Brian is, what are the new changes we should be careful about? Well, the most important change is essentially getting across the information, the Australian privacy principles. There's plenty of good information on the Office of the Australian Information Commissioner. They've summarised the Australian privacy principles and focusing in particular on the first one. The first one sets out what needs to be in the Australian privacy policy, the APP privacy policy, and also making sure that you've put these procedures and processes in place. If you don't do that, then you won't be able to defend any complaint or if the Information Commissioner comes knocking on your door and you don't have the documents and the procedures in place, it's going to be difficult to defend any potential claim, and that's going to expose you to potential fines. So that's the most important thing. Sorry, there's a couple more questions that have come in. I'll just go back up. Glennis, yeah, you can get a copy of the slides. I've emailed the slides to Bronwyn, so Bronwyn, that's fine if a copy of these slides go out.
Thank you very much, Matt. It's Bronwyn here from GP Connections. We appreciate your presentation there. Hopefully, if anyone else has any further questions, they can get in contact with me and I can ask Matt for you, or else I'm sure he'd be happy to answer your questions. If there are no other questions, thank you very much, and I hope everyone enjoyed the session.